Mr. Waldron?
May it please the court, counsel. I'm Pat Waldron, and I represent JBS in this matter. Your Honors, this matter is about the exchange of workers' compensation. The exchange to employers, and it's a fair one for the most part, that we forgive and forget any liability of the claimant, injured worker in the state of Iowa, in exchange for statutory limitations on recovery. This matter flies in the face of that exchange. This matter flies in the face of law that's well established statutorily that prevents a double recovery under that statutory exchange to employers in the state of Iowa.
Isn't the compensation under the workers' compensation system basically all statutory? And there's no common law to it.
No, it's a creature of statute, Your Honor, yes.
And, you know, I understand the commissioner's argument when they changed the law and had a new apportionment rule. They sort of got rid of some sections that would have made it very clear that you're right. I mean, but they left the section that you're relying on, but the problem was it seems like they thought they needed those other sections to make it clear, and then redid the apportionment. I mean, how do you explain taking out the section that made it very clear what happened in this case shouldn't happen?
Your Honor, when the apportionment issue was front and center, the apportionment issue dealt with an industrial disability awarded that apportions off a previous industrial disability. This notion of a new man, this notion of I'm injured in one setting with the same employer, and then I enter into a new setting after suffering an industrial disability. The thought was that the subsequent entrance already allows for a loss of income, and we can then apportion that loss in an industrial disability setting because of the reentrance into the same employer. To give a number example, I suffer a 15% industrial disability with JBS. I re-enter their workforce ostensibly at a lower wage, but we know in reality that doesn't occur.
Well, I understand the merits of your argument, and it has some things, but where does the statute do it? I mean, that's the key. And the section you cite, for some reason, without that other section, doesn't seem to get me there, and you have to tell me why that section gets me there.
And I think that 8534.7 was redrafted to provide for what wasn't there, to provide for an apportionment from the same employer in an industrial disability setting. What was left there was to provide for apportionment in a permanent total setting, because it makes no sense to apportion off a permanent total, essentially. In other words, if I suffer a 20% industrial disability and then later have a subsequent injury, and I enter into the workers' compensation system and I ask the commissioner to award me a 60% industrial disability because my new man under 8534.7, I'm a 60% industrial disability. In that context, practically, defendants, employers, same employer, says, hey, court, go ahead and subtract off the first 20%. The money I owe now is 40%, 200 weeks of benefits.
Didn't we cross this bridge in the Davis case?
You did not, Your Honor.
Well, I mean, looking at what was the situation was going into the 2004 kind of sausage-making exercise that occurred after there was the ruling by this court, and there had to be the special session, and there was a lot of negotiation. Going into that situation, you had one statute, which is the one you're relying on now, that said basically you can't get duplicate benefits for the same injury. Then you had an apportionment statute that applied both to partial disability and to total disability. And somehow, when the sausage-making exercise was done, the apportionment for total disability got dropped. Now, I don't think that's what the legislature probably meant to do, but it does seem to be what they did.
I would disagree with
wrong?
you. Yeah, I do think you are, Your Honor, respectfully. I think it was not dropped. The thought was it was still there. It's still there in exactly what we cited. It's still there. It's mentioned in 8534 It's left there, and the
So
apportionment.
it was there in that section, the section that they dropped was surplusage then. I mean, the section that they wrote out was surplusage for all those years. If your section took care of it, and that doesn't make sense to me from a legislative construction standpoint.
Well, clearly, from a legislative intent standpoint, first and foremost, in all the legislative intent in 8534, it says, we are here to avoid double recovery. And what is before you but a double recovery? That cannot be mistaken. So if we're talking...
The argument can be made in Davis, they got a double recovery because they offset a permanent with a schedule, and you can't do that. I mean, we can only, whatever their intent is, we can't divine it. We have to use the words they use, and that's where I'm having my problem. And I don't know if anybody else is, but that's where I am.
Well, Your Honor, the words they use, that no compensation shall be payable under this subsection for any injury which compensation is payable under subsection 2 of this section, speaks directly to that. That is
We have two different injuries here. I mean, isn't that right? We have the hernia, and then we have the shoulder neck injury, right?
the hernia led to 70%. The shoulder neck injury led to the permanent total. But Iowa law doesn't differentiate shoulder, neck, back, head, mental. It all falls under the same subsection of industrial disability. Yes, Your Honor, it all falls under the same subsection of industrial disability. We have scheduled members for hands and arms and legs and so forth, but when it comes to body as a whole injuries, it all flows through the same subsection. There's not a separate section for back and a separate section for hernia and a separate section for shoulder. It all flows through the same section. So when we talk about avoiding double recovery in the permanent total sector, you've got to look at this section and make a differentiation between that contract employers make to pay their fair share. But it makes no common sense, it makes no statutory sense, and I think it flies in the face of both the legislative intent and the Code Section 8534 3B that we would allow a recovery that's $154,000 or so greater than what the statutory construct requires of an employer who's made that exchange, that statutory exchange. Your Honor, that's the first point of our brief. The second point is more of a substantial evidence point, and that is that this award of industrial disability was likewise illogical when you look at the whole of the evidence, that awarding a 70% for a hernia in the first place and then a permanent total on this evidence was wholly illogical. But again, the overriding issues of avoiding double recovery, and you do have a statutory mechanism that provides for that. In fact, the deputy applied that statutory mechanism. The deputy himself mentions that we avoid double recoveries in his very decision. It was the former commissioner who then overturned that deputy. I appreciate that.
We don't look at the deputy decision. The decision that we are looking at is the commissioner's decision, and that's the one that's appealable. And then the deputy's not, if we looked at these deputy decisions or other original decisions in all these administrative law cases, I think it'd be a mess.
And even the commissioner noted that he was concerned with the double recovery that he was awarding in this instance, as was the district court. And then that led to us being here today, Your Honor. And even from a common sense standpoint, employers of the state of Iowa look at this type of decision where they are required to pay not only a 70% industrial disability, that would be a weekly check for 350 weeks, but then on top of that, send the same weekly check or greater for the lifetime of the claimant during the same period of time.
Doesn't that require a legislative fix? And since Davis, they haven't changed the law. I mean, that's been there for a few years.
Yeah, Davis has been in play for...
And legislature never blinked at it. They left the law the same.
Davis has been the law since 2009, but Davis also was looking at 8534.7, which was the sausage mix that was 8534.7. This is a different case. this case says to employers, we are not going to have you duplicate payments after already paying for an industrial disability if you're awarded, if the claimant is awarded a permanent total. We will not have that because our statutory system allows it, the legislative intent spoke to it, and from a common sense standpoint, that's not fair to the exchange to employers. Thank you, Your Honors.
Mr. Byrne?
May it please the court, counsel. My name is Jamie Byrne. I represent Ms. Ochoa. I've been involved in this for years, this case, from day one. This is the Drake case, without a doubt. And I know that counsel has tried to indicate that it is not, but that is simply incorrect. And before I go to why this is the Drake case, I would also add, as noted by the Court of Appeals, that the argument that they have now raised on judicial review and appellate review under Iowa Code Section 8534-3B was never raised before the agency and therefore was waived.
Well, wait, but they won in front of the deputy, and then you argued in front of the commissioner that there shouldn't, that these overlapping benefits were okay. And then as I read JBS Swift's response, they said, well, under the statute, you shouldn't have overlapping benefits, but they didn't specifically cite, I agree to that one provision, but they certainly raised the issue. I mean, the issue has always clearly been in place since you raised it really in front of the commissioner, right? The underlying issue?
Well, I think that, okay, so the way that this happened was you have the arbitration hearing, the arbitration decision. The arbitration decision, the deputy says 70% for the hernia, permanent total for the right shoulder for the subsequent injury, okay? Without any justification or mention as to why he was doing it, he said the permanent partial disability benefits under 2U cease upon the commencement of the PTD under 3, okay? And so I cross-appealed. They appealed and I cross-appealed. And then on the cross-appeal, I said, you know, and at no point did they say, wait a minute, 8534-3B governs because this is the same injury, because it's not the same injury, okay? And so I appealed and I said, this is the Drake case, all right? So the deputy got it wrong because in reality, you have a PPD, permanent partial disability award under, by a PTD award under 8534-3, which are two different subsections, and therefore Drake applies. The first time, so they then in their reply brief to my appeal said, no, 8534-2U, really what should happen is it's no longer permanent and partial disability, it's PTD, so it should just stop. They didn't reference 8534-3B as if it's the same injury, which they are now trying to do and did for the first time on judicial review.
Well, they're not saying, they're saying it's all, they're really saying there isn't a same injury requirement under that part of the statute, which is consistent with what they were arguing in front of the commissioner, right?
I think what, I'm sorry, go ahead.
Go ahead, no.
I think what they're saying is, what they raised the first time on judicial review is, this is the same injury, and therefore 8534-3B applies because the commissioner looked at not only the disability that was there for the hernia, but basically also looked at the disability that was there for the right shoulder, which was the camel that broke, the straw that broke the camel's back.
Let me talk about, I mean, I think you're making some fairly persuasive points under the statute, but let's talk about the practicality. Now, according to the record, your client, when she worked at JBS Swift, her final wages were $680 a week. Now, as a result of this, the way the commissioner ruled, she gets 6 years where she gets both $450 a week in partial disability and $450 a week in total disability. Now, normally, we don't you think we would assume the legislature doesn't intend to arrange for people to get paid more for not working than they're getting paid for working?
Because, as noted earlier, this is a creature of statute, I don't think we assume anything when it comes to the legislature. I think it's strict construction, which is exactly what Drake did, and that's this case. I understand your point. I do. At the same time, if we want to talk about somebody who's been removed from the workforce, we also understand that that's a limited period of time where they're getting those benefits. And in workers' compensation, they don't get increases for cost of living, health insurance benefits, 401k benefits, things of that nature. So if we're talking equities, which we're not when it comes to statutory construction and workers' compensation, then we can talk about several things that she's no longer going to be able to get for the next 20 to 30 years. But that being said, the point in this case is you are dealing with two separate injuries. Therefore, Iowa Code Section 8534-3B, which they have cited, which I think has been waived, but to the extent it has not been waived, which they have cited to, is not applicable to this case. There are two separate injuries to two separate body parts that are temporally different. You have a February 2011 hernia injury. You have a December 2011 right shoulder injury. You have two separate petitions that were filed, two separate file numbers that were assigned by the agency, two separate weekly benefit rates. And the only reason that these cases were tried together were for judicial economy. So in reality, this is the Drake case. And Drake, he had a 2002 injury to the back that resulted in a 30% industrial disability. You then had a 2004 work injury that resulted, let me back up, the 2002 injury to the back with a 30% is under 8534-2U because it's permanent partial disability. The subsequent injury in 2004 under Drake was a back injury, which they determined was under 8534-3 permanent and total disability because now the person was permanently and totally disabled. The exact same arguments were made in the Drake case because there was an overlapping of benefits. And what the court in Drake did, it says, look, we are not going to read into the statute. Essentially, we generally do not apportion the benefits from two successive work-related injuries without a statute allowing us to do so. The plain and unambiguous language of Section 8534-7 indicates the only benefits subject to apportionment are those awarded under 8534-2. Section 8534-2 benefits include scheduled benefits and permanent partial disability benefits of the body as a whole. The agency in Davis awarded permanent total disability under Code Section 8534-3, not 2U. So PTD benefits, permanent part.
What would be the policy reason for the legislature to provide for apportionment of two injuries resulting in an increased level of partial disability from the second injury, but not for apportionment when there's a partial disability followed by a total disability? Why would you have apportionment in one rather than the other? What would be the policy reason for doing that?
I don't know. And they didn't do it. And they had it there before, and they got rid of it. Under 8536-9, I think it was, they didn't allow for it. They redid the statutes, and they did not include it. I understand the argument, but if we're looking at workers' compensation is indeed a creature of statute, you go with strict statutory construction. As the district court said at the judicial review level, looking at House File 2581, it said it is the intent of the General Assembly that this division of this act will prevent all double recoveries and workers' compensation benefits for permanent partial disability. It did not include permanent total disability. Now, the section that they're referring to that does not apply because it's not the same injury does allow for a reduction in benefits in permanent total disability if it's the same injury.
What about this part of the statement of intent? Again, these statements of intent, they're helpful and maybe they're not so helpful. But what about this portion that JBS Swift relies on? The General Assembly intends that an employer shall fully compensate all of an injured employee's disability that is caused by work-related injuries with the employer without compensating the same disability more than once. Doesn't Swift have an argument that what happens here violates that statement of intent?
I think what they're talking about is the same injury. Disability and injury are not synonymous. Okay? So,
that's why that's a different statement, isn't it?
Yeah, I think it's the same injury. I mean, you can have an injury under workers' compensation where there's no disability at all. Temporary injuries happen all the time where somebody doesn't miss any work and they don't have any permanency, so therefore they don't have any disability. Okay? But when you're looking at workers' compensation, you have two separate injuries, you have two different assessments with regard to whether or not those injuries result in disability. And then you have to look at all the factors of disability. In this case, under 2U, you look at the disability for industrial disability. The point in this case, and they're referring to 8534-3B, is they're saying, and if you look at 8534-3B and you need to read it, it specifically says same injury, okay? Counsel read the first sentence, not the second. okay? First sentence reads, no compensation shall be payable under this subsection for any injury for which compensation is payable under subsection 2 of this section. Fine, okay, let's move on. In the event compensation has been paid to any person under any provision of this chapter for the same injury producing a permanent total disability, any such amount so paid shall be deducted from that permanent total disability award, okay? So what's the difference, okay? That case references, I believe, a situation where, for example, I have a hernia injury on the job. I get awarded a 70% disability, okay? I go about my business, I continue to work. 2 years later, within the statute of limitations to file for what we call review reopening, I get worse because of the same injury. I then refile a petition. I go to the commissioner's office. They give me an arbitration decision that says you're permanently totally disabled as a result of that injury now. So now what that provision kicks in and says, okay, it's the same injury. You've already got paid this amount of benefits. Therefore, we will reduce from the amount of PTD that you're owed the amount that you've already been paid. That's when it's the same injury. This case has two separate injuries, and that's why it's important. If you look at the strict language of the statute, this case is the Drake case because you have two separate injuries. Yes, there's some overlap in benefits, but they're two separate injuries. So 8534.3 does not apply. Mm-hmm.
And I never did any workers' comp, so this may be a silly question, but wasn't part of, what effect does the commissioner give to the 70% that you already had? So I know you have two separate instances or two separate incidents where the first one's the hernia that gives you a 70% industrial disability. If correct me on all this if I'm wrong. Then you have the second injury that affects your neck. It sounds like neck and arm. But what's the effect, or how do they weigh the 70% that's already there? I mean, is the 100% of the injury, the permanent disability, just on the shoulder? Doesn't that consider as part of an accumulation of things of your body that makes you 100% permanently disabled? And again, that may be so basic that it's ridiculous, but didn't they consider that and say, well, yeah, this injury itself, maybe that alone would have been the other 30%, but built on top of the 70%, isn't that get you the 100, or that's just not the way it works?
Well, I mean, it's a good question. Fundamental workers' compensation law says you take them as you get them at the time of the injury, okay? So if I have a 70% injury, then I have 10-pound restrictions for a hernia, as she did, okay? I continue to work full duty, and then I develop a subsequent injury, which she did, to her right shoulder and neck area. I now have more restrictive restrictions given to me that takes me out of the job. So you look at the entirety of the disability. 8534.7a says an employer is fully liable for compensating all of an employer's disability that arises out of in the course of the employee's employment with the employer.
So
you have to look.
Is that the concept of a new employee or a new start type of?
With regard to that injury, yes, it's a fresh start. You look at the person as they are at that time, and you don't ignore what they already brought to the table. And so you take them for the entirety of the disability, even though there's two separate injuries. I think that's very important. With regard to the statement on substantial evidence, I would just add that with regard to the 70% industrial disability, really that goes, as you gentlemen are well aware of the substantial evidence standard, conflicts in the evidence. The bottom line is this lady had surgery on her hernia. She then tried to get back to work, did get back to work. She was then given significant restrictions by one of the treating doctors, which was then agreed upon by another evaluating physician, which was not in any way rebutted by any physician on their part with regard to the hernia. And the deputy noted that because of her lack of education or lack of retraining, she had substantial disability as a result of that injury. Then coming forward to the injury in December of 2011 to her right shoulder area, she was removed from the job by her employer, by her doctor, and then shortly thereafter fired by her employer after she'd been complaining about the right shoulder injury. I had to file for unemployment, fought it. She then won it. But the point is she was removed from the workforce at that point in time because of the severity of her injuries. And she never made it back to regular full-duty gainful employment thereafter. So that being said, I think that substantial evidence supports not only the 70% award, which gave her severe restrictions, nonetheless she continued to try to work, And then obviously the December 2011 award to the right shoulder, which then took her out of work in terms of full-time competitive gainful employment. Thank you.
Mr. Waldron, any rebuttal?
Justice, you make a good point. The statutory construct of workers' compensation benefits starts with the weekly rate. We establish a weekly rate based on the average weekly wage of the claimant, and we apply that for the life of the industrial disability or permanent total disability. That rate is, again, part of this exchange to employers. It says you're going to voluntarily pay this essentially 80% of take-home earnings without regard to fault.
But aren't you forgetting the other part of the grand bargain, which is that the employee loses pain and suffering, the employee loses all the consortium claims that go along with it, the employee gives up a whole lot of damages that would normally be recoverable in exchange for sort of a strict liability system. So when the legislature writes the law that makes these positions, I mean, you have to consider all the things the employee gave up too. I mean, you just can't look at it from the employer's side.
Yeah, the employee generally gives up the right to sue the employee for negligence.
The damages
and
are a lot
damages.
different. And the employee also gives up the right to keep the award for their whole lifetime, because if there's a change in circumstance, the employer can come back in and change the award.
And so we base that exchange, whatever the contract benefits to each are, on a weekly benefit rate. That weekly benefit rate governs the case for the life of the case. The legislature never contemplated doubling that rate in certain circumstances. Instead of paying $400, employer, we're going to ask you to pay $800 for a certain portion of this statutory construct. That is never envisioned. And if that is the product of statutory construction, the notion that we strictly construe the statute because it's workers' compensation isn't tantamount to throwing out all the other statutory construction.
Can we rewrite the statute when it's unambiguous?
No, Your Honor, but I don't think it is unambiguous. And when we look at it, and it says specifically, no compensation under this subsection should be paid for any injury, which compensation is payable under subsection 2, and we all know 2U is the industrial disability section.
But your argument has to be for any disability, because it's disability under body of the whole disability, but they are separate injuries.
Yes, and so we don't have a same injury requirement here. It says for any injury. The subsequent context, keep in mind we have review reopening, which allows for the same injury, and this is what the second section of this surely speaks to, at least in one example, where we have the same injury and an employee comes in after receiving an award. Let's say, for example, in the hernia case here, the claimant receives a 70% award. That same employee can come back to the commissioner and ask for more if their situation changes. In that context, if they're awarded a subsequent permanent total disability, we don't run the two benefits on top of each other. We pay it out as a permanent total disability under one $400 check a week. The notion that there could be cases where the two overlap this is the statute for that. It says for any injury. There's no single injury requirement here.
You're in the second sentence that Mr. Byrne quoted.
Yes, but that's in a different context. I mean, it says if they arise out of the same injury, we are going to deduct it as well. But
I agree with you. If I was the legislature, I wouldn't adopt a system that essentially disincentivized work by authorizing more in weekly benefits than someone was getting when they were working, especially in situations where, like this, where there's a disagreement in expert testimony and the claims are somewhat subjective and it's hard to evaluate it. But having said that, didn't we have the same situation in Drake? We had the person was permanently disabled and was able to collect both the permanent disability benefits and the the total disability benefits and the partial disability benefits at the same time.
That under 8534.7, which you used to arrive at Drake, there were two different subsections used in that case, And 8534.7 prohibits apportionment when there are two different subsections, scheduled versus non-scheduled. Here, Your Honors, we're not asking you to do this under 8534.7. We're saying, look to this law. This is the law that prohibits it, because any contrary reading of Iowa workers' compensation law would be to throw concepts of illogical and absurd results in statutory readings out the window, and instead opt for a reading that tells employers we are opting for an illogical and absurd result in this case and any that follow it, where a claimant would receive $800 for work they were paid to do $600 for, where they would receive 2 workers' compensation checks when the entitlement clearly under the statute is only 1. And I just submit to Your Honors that that is not the exchange that Iowa employers opted for. That is not what the legislature intended, clearly by the legislative intent and by the statute, and that is not what Drake was evaluated under at the time. Drake was evaluated under 8534.7, Your Honors. This statute allows for the correctness in the outcome that would say to an employer, and frankly to an injured worker, when you are permanently totally disabled on the heels of an earlier overlapping industrial disability, you only get 1 weekly benefit check. And that was addressed by this very section. Thank you, Your Honors.
Thank you, Mr. Waldron. This case is now submitted. You may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.